almost everything that Larry said. Let me just particularly indicate that I agree with Larry that a term which might be vague, right, and which has a conventional semantic meaning that's vague, right, and cool is a good example here, could, in the context in which it's uttered, actually become a non-vague term. So, and I accept that the example involving Larry's mother could, right, given the right set of circumstances, be such a case. And it could be that there are terms in the Constitution that have conventional semantic meanings that are vague, but that acquire a non-vague sense or a less vague sense, given the publicly available context of constitutional utterance. And I just use that phrase, publicly available context of constitutional utterance, because on my theory of meaning, it has to be a publicly available context, whereas on Larry's theory of meaning, not necessarily so. So that I just agree with completely. And the only thing that I disagree with, and it's not really so much a disagreement as it is a clarification of my position, concerns Larry's discussion about construction requiring moral values, right? And so I want to clarify here. And just an excuse, I hate to offer excuses, but I did send the paper in about 10 minutes after Michael told me he would need it. So if I had known, say, even 2 or 3 days in advance of when it was really required, given the time frame, I would have revised the paper to reflect remarks that Michael made in a debate with Randy and that John Rappaport made at the ALS. John McGinnis made at the ALS, because they make important points that require clarification. So here's just one thing I want to say is, when I say that construction requires normativity of some kind, I mean that theories of construction have to be justified through some kind of normative argument, where I understand normative in an expansive sense to include purely legal arguments or moral arguments. But it's not my view that construction requires that we engage in our first order normative judgments about the particular question. In fact, that's not my view. The view that I think I'm likely to develop will suggest that that is inappropriate. So I just want to make it clear that my view is not that construction requires we analyze the particular question of constitutional construction from a specific moral perspective. But it could go that way. And I take that moral readings views of what I would call constitutional construction do go that way. Right? So I want to make that thing clear, that I'm not, I do not believe that construction requires that we attend to moral value. And in the first order sense, as opposed to in the second order sense, that theories have to be justified by some normative account. And then the final thing I would just say is that it is from the distinction between interpretation and construction, it does not follow that interpretation runs out. If you can develop, as McGinnis and Rappaport attempt to do, a theory of interpretation such that there's no room for construction, right, then construction would turn out to be a trivial step. The one thing I would say is that their theory, like all theories of interpretation, has to respond to the facts, and there's a big argument to be had about whether or not their theory as opposed to my theory as opposed to Larry's theory is correct on the facts as a matter of general linguistic theory, the philosophy of language, and the particular circumstances of the Constitution's linguistic communication. That debate has to be had, but it does not follow from the distinction that it is necessarily the case that meaning runs out. That's it.
this privilege of asking a question first. Although you said we're not advancing at this point a theory of construction, I would like to sort of explore with you the possibility of reflecting on the institutional aspects that a theory of construction might have. It's interesting, there's a quirk in the US system. When we're talking about construction, we're talking about what we do when there's undeterminacy, vagueness, ambiguity in the text. The quirk of our system is that we've got linguistic underdeterminacy about who gets to do the construction within our system to which other political actors have to defer. Right? The text itself has this problem within it, that it doesn't give us a conclusive answer as to who gets to be the conclusive constructor for everybody else. When you read Hamilton making the case for the life tenure he wants to give to these Supreme Court justices, it's all about how syllogistic their reasoning is and how much expertise they need in order to get it right. And that's why you've got to give them life tenure, because they've got to be reading these books forever in order to get it right. It's something that clearly your average, model person can't do. It's got to be these law people, right? And when Madison responds to Dr. Johnson's proposal to add Article 3 arising under the Constitution bit of the arising under clause, Madison says, well, as long as that's limited to matters of a judiciary nature, right? And then it being generally supposed that it is so limited, they just, oh yeah, let's do that. So what does this mean? Maybe it's a political question, but they'd debated if it was a political question. They were thinking, oh, probably it's advisory opinions that Madison's worried about. Why is he worried about advisory opinions? Well, because then you're lecturing the whole society about what the deal is, about what this text means, as opposed to simply just resolving a dispute for two little people who are in front of you, right? So the vision we're getting from these founding figures is one of that doesn't help us out much with the question, who gets to be this conclusive constructor? And more contemporary constitutions handle it by having back and forth, right? The Canadians, the legislature gets to come back at them and say, well, notwithstanding, we're going to pass this thing anyway. And Britain, they can decide whether they want to adopt this judicial, we bring into law this judicial interpretation, right? So how do we wrestle with this quirk of our system that we've inadvertently set up a system where someone defaults to being the conclusive constructor?
So I'm sure that this will be a frustrating answer, but I have no position on that question. Yes, I have no position on most sort of substantive questions of constitutional law. I have some guesses, right, about how it would come out, but from my perspective, I would have to go through all the work, first of figuring out whether the text does or doesn't answer the question, which I don't think it's clear it doesn't, right, but you might be right. And then I would need to develop an appropriate theory of constitutional construction, which I don't have. So I have no answer to your question.
Larry,
I think it's an excellent question, and I think I just want to make one comment. I think the case for strong judicial review is a strong case when we're dealing with interpretation in the empirical sense. Once we are beyond interpretation, I think the case for judicial review, particularly with strong, Cooper versus Aaron, and judicial review, is relatively weak, notwithstanding things I may have said in the past.
My grandpa.
Okay, so the way I'm going to put this is I'm going to ask Larry a clarifying question about interpretation and construction, in particular construction, because I think I'm getting closer to understanding it, but we shall see. So I'm wondering if there's, and maybe this is part of the two tracks idea, but maybe it's not. I don't think it's part of the two tracks idea, but so some of the time I hear you make the following kind of point, which is to say construction operates when there's ambiguity or vagueness or something else, right? We figure out the meaning through interpretation, whatever our method is, and then when we've got what's left over whatever that might be, then we have construction, and maybe that's the construction zone. That's at least, I think that's the way Larry Alexander defined it. Then at other times, you describe it, I think in the paper actually, it's interpretation is figuring out the meaning, and construction is coming up with the legal rules, right? So, and I think those are two different enterprises. Maybe they're made compatible, but to take just the most obvious distinction, if we have some unambiguous language, then that has clear meaning, presumably that language still gets a construction, right? You say we won't notice it, but you have to decide, you know, when there's two senators that you're actually going to enforce that.
Right.
So I'm confused because some of the time I think that construction is not, so under the first definition of construction, it doesn't happen all the time. It only happens when there's ambiguity or vagueness. And it's not something, and under that view of construction, I don't think it happens very often because I think interpretation answers most questions. Under the second understanding of construction, which says it doesn't matter whether it's ambiguity or vague or not, once we figure out a meaning, we have to decide to translate that into a legal result, and even if it's exactly identical with our meaning, we still, you know, going to do that. It's invisible to us, but it's construction. Well, I guess I'm willing to accept construction in that sense because it's you know, sort of almost a defining aspect of a process. So I was wondering if you could help me come to terms with both of these ways of putting it, because they seem to be different, and it sometimes confuses me.
Right. So good question. And I think my own view here has changed in response to closer examination of what the distinction actually is. Right. So I think that you can talk about it both ways. Right? The fundamental distinction is the distinction between determining linguistic meaning and determining, or the semantic content of the text, and determining doctrine, constitutional doctrine, or the legal content of the corresponding rules of constitutional law. And that means that the fundamental picture, the picture that at bottom is most fully accurate, is the second of the two pictures. That is, there is always construction. There is construction even when you're talking about a rule that says two senators, because you have to translate the semantic content into legal content. And it's theoretically possible that there would be a difference, right? Although in that case, there certainly isn't a difference. And in my view, on my tentative views about construction, there shouldn't be a difference. So then how do you get, if that's the fundamental distinction, how do you get this other picture, right? And this is the point that I try to be careful about, but it really is a subtle point in some ways, that in some cases, interpretation is the thing we notice because interpretation is doing the work, right? And this happens when either the linguistic meaning of the text is obvious, right? So that the construction step just disappears. It's not that it doesn't happen, it's just that we don't pay any attention to it because it's so automatic that it doesn't require any mental effort, right? Or the case where the text is ambiguous, and by taking into account the context of utterance, we can sort out which of two senses is the linguistic meaning. But then once we've done that, right, it might be that further construction is not required, or it might be that we do need further construction. That will depend on whether the clarification of the ambiguity is sufficient to resolve the legal problem at hand. Likewise, there are cases where we don't pay much attention to the interpretive activity because it's obvious that the phrase is vague. And then setting aside accounts like your account and John's account that think we can resolve that kind of vagueness by resort to original methods, and that does yield a linguistic meaning. Setting those theories aside, it will seem obvious it's vague, and so we'll say, well, this just requires construction, right? We're trying to draw the line between executive and legislative power. That's an occasion for construction. Construction is doing the work, right? So my view is that fundamentally there's always interpretation in construction, but sometimes interpretation is the activity that we focus on, and sometimes construction is the activity that we focus on. And that's why, right, you can think of these as two alternative modalities, because in a sense, for practical purposes, when we're sort of actually doing the work, we may be doing one or the other, but there are cases where we do both, and those would be cases, for example, where we have to do interpretation first because we have to resolve an ambiguity, and then it turns out that in the relevant sense, the sense of the term that is the original meaning or the intended meaning is vague, and so now we have to also do construction.
So I would just want to follow up just with a sort of friendly suggestion. I think it's intended to be genuinely friendly, which is you might want to actually, in the paper, talk about, maybe even have two, have an adjective, talk about construction in the case where there's determinate meaning, and construction in the case where there's vagueness. Because, and in that way, because I think some people walk around thinking that construction just means when there's vagueness, and so anyway, I think that would help.
And I think that for quite a while, I was talking about it in the alternative way, right? And I believe there's a reason for that. It was that I had not yet investigated the fundamental basis for the distinction. That is, I was looking at a surface manifestation of the distinction rather than the fundamental basis for the distinction itself.
Tom?
So I guess my question directly follows on Mike's, and maybe it's just the lateness of the hour, but I'm kind of confused too. So some of the times you talk is that, I can see there's in my mind, three different ways in which this distinction might work. Sometimes you talk about the nature of the interpretive problem, ambiguities where a word might mean multiple things or these two different things. We're trying to resolve which of those meanings was the one intended by the author of the text. If that is interpretation, but we're kind of chopping down a very broad term to a narrower meaning or doing something like that, but we're engaged in construction. But another distinction just might be in terms of the, whether we're focusing on the types of arguments that we make in terms of resolving these disputes. So, are we looking? Does interpretation just refer to an activity where we look at the text, the context, maybe the legislative history, to try to figure out what the author meant, as opposed to using other constructional devices, which is then other interpretational devices, which is construction. The third possible meaning is, construction involves sort of like overt use of substantive or normative concepts to resolve interpretation questions or meaning questions. So, to take some simple examples from legislative interpretation, are canons of linguistic use interpretational or are they constructional? Is the doctrine of lenity or the doctrine of avoidance of constitutional questions, is that instructional as opposed to interpretive? I'm just a little confused about whether the distinction goes to the nature of the question that's being asked, the sources that we're looking to in answering the question, or the types of arguments that we're making in answering the question.
So
some combination.
The distinction goes only to the actual distinction itself, as opposed to the manifestations of the distinction, the implications of the distinction. The distinction itself goes only to the distinction between the activity of determining the linguistic meaning of the text, which is interpretation, and the activity of determining the content of doctrine that is attached to the text, right? That is the activity of construction. So one is about semantic content, the other is about legal content. But once you have that distinction in place, then it connects to all of the other things you just described, right? So let me just get, so vagueness, ambiguity, the reason it connects to vagueness and ambiguity is because in the normal case, although I think that there are exceptional cases, in the normal case, ambiguity is a matter of figuring out what the linguistic meaning or semantic content was. And the normal way that we do that is by taking the utterance and looking at the context of utterance. And that, in the normal case, resolves the ambiguity, yields a semantic content. Vagueness, on the other hand, on my account of vagueness, but not on Mike and John's account of vagueness, vagueness on my account, once you have done all the work Larry says you have to do to make sure that you have, in fact, understood that in the relevant sense of the term is, in fact, vague, which it may or may not be, right? But once you have done the work and you've gotten the semantic content, and the semantic content is vague, then construction is required. So vagueness, ambiguity maps on to the distinction between interpretation and construction in that way. It isn't the distinction, but it's a manifestation of the distinction. Likewise, just talking about canons, right? Canons of statutory interpretation. This is not something I thought a lot about, right? But I would say that we could use the distinction to divide the canons up into two types. That we could say there are canons of interpretation and there are canons of construction. Canons of interpretation would then be understood as more or less rules of thumb. And they would describe principles that we use to understand the linguistic meaning of an utterance that have been summarized for us by judges who run into typical interpretive problems over and over again, and so they come up with rules of thumb that summarize the solution to the problem. Canons of construction, right, operate on the legal consequences of the semantic content of the text. And I would take it that the avoidance construction would be an example of this.
So let me give you an example. The Mann Act says that it's a federal crime to transport a woman or girl in interstate commerce for purposes of prostitution, debauchery, or other immoral conduct. Okay? And so the question is whether or not taking a girl in interstate commerce to have an affair with her is a violation. So if you said other immoral conduct is to be interpreted according to Noscitur Associs, it's known by its associates, and one of the associates is prostitution, that it has to mean commercialized sex, that would be an interpretation. But if you said that we're going to interpret it to avoid having an affair because of the doctrine of lenity, that would be that'd be a rule of construction.
Yes, yes. I mean, you can imagine the first rule in some context operating as a rule of construction, but yes, as you have presented the example, that would be exactly the distinction.
Jim?
Yes, my question concerns the relationship between your distinction between interpretation and construction and Keith's distinction. And this may turn out to be more a question for Keith. Because as I confess, it's been a couple of years since I read Keith's book, Constitutional Interpretation, and his book, Constitutional Construction. But as I recall it, for him, interpretation is for courts, and it is originalist. Construction is for legislatures and executives, and it is not originalist. But I see you as using the terms in a pre-Keith kind of a way, in more of a classical way that we see interpretation and construction in legal discourse. But I don't see it as, I see it as using Keith's terms, but not but as being you're trying to bring both interpretation and construction within your new originalism, and it's something that courts do. But I thought Keith construction was what legislators and executives did.
So I'll be very interested to. I have a theory, and Keith may or may not accept it. Right. So my view is that this difference is a difference in is not a difference as to the meaning of the distinction itself. Right. So my understanding is that at bottom, the distinction we're relying on is the same. The distinction, right? But Keith has a theory about the implications of this distinction. His theory of so I would just reconstruct his account in my vocabulary, which is slightly different. So I would say Keith's theory is that courts do interpretation, right? And then when they have a linguistic meaning that can be translated into legal doctrine that resolves the case, right? And according to me, that's construction, but it's this very minimalist form of construction. It's just direct translation. Then the court can resolve the case. But if you hit a case where more than that is required, where the act of construction would involve, for instance, the kind of line draw that would be required to resolve vagueness, then it is appropriate that part of construction take place in the political branches. And then that's my understanding of Keith's original position as it was articulated in the books, right? And then there's a further question whether Keith now thinks that that there aren't appropriate occasions for construction in the courts. For example, the kind of construction that Larry identified in his remarks. But we don't really have to rely on my view of the relationship since Keith is here. And I'm very interested to hear what he says about this.
Yeah, I'm actually, I think the books emphasize the construction would occur, emphasize the extent to which construction does occur and really ought to occur outside of courts, although I gave some slight examples of construction occurring inside of courts as well. So, the sharp distinction I wanted to make was not between construction is something that occurs outside of courts and interpretation is something that occurs inside of courts. I thought interpretation can occur in both places, construction can occur in both places, but normatively it would be preferred if construction occurred primarily in other contexts, although I think since then it's sort of recognized that there's a lot more constructive activity that could occur in courts than I initially anticipated. But I think actually the thing that struck me more than that about your paper was whether you were using the distinction differently than I was on another dimension, and that is whether your construction in particular was doing something quite different than what I was doing. The interpretation is really very differently. But the notion of construction seems to me to be framed quite differently, really, than how I frame construction. And it seems to me it points in some of the ways to what Tom was puzzled over as well, and that so you frame construction particularly as translating linguistic meaning into legal doctrine. And of course, my examples from outside the judicial context, which is the primary examples I use of construction, don't have anything to do with trying to translate linguistic meaning into legal doctrine. They're not about legal doctrine at all, and that's primarily what I was thinking about construction in terms of was these sort of political examples. But more generally, thinking about both construction and interpretation as being about the same kind of activity, as they're both efforts to try to figure out what the Constitution means, although one in a context in which meaning is relatively determinate, and the other in the context in which meaning is relatively indeterminate. Whereas here, construction seems to focus more on an effort to translate meaning into, or focuses less on constitutional meaning itself than the development of implementation rules and the like, which may no longer be very focused on constitutional meaning or the search for constitutional meaning at all, although sometimes it might. And that seems to be taking what constructions are in a quite different direction. And so while I think some efforts to think about legal doctrine, it makes a lot of sense to talk about them in terms of constructions. There's a lot of types of legal doctrines that it just doesn't seem like they're aimed at trying to make sense of what the Constitution means at all, and therefore it would seem like thinking of them as constructions seems to be taking constructions in a quite different direction than I was thinking about it anyway.
So,
Sorry, can I get on?
Sure, put you on.
Thanks.
so I think that I want to say, what I think I want to say about this is that I actually believe that at bottom, the distinction we're after is the same, right? And so I want to, but I want, so let me just bracket these implementing rules that Larry is talking about for a moment, right? And talk more directly about what goes on in the political branches as opposed to what goes on in the court. So when I say legal content, right, I don't mean to restrict that concept so that it only applies to judicially generated doctrines, right? So that it would be perfectly possible that we would have a constitutional provision that it needs to be clarified, right, in some way, and that the way it was clarified involves the development of a practice, right, by the political branches that has implications for what the content of constitutional doctrine in an inclusive sense is, but is never reduced to a rule that any court would ever talk about. In fact, it might never be reduced to a verbal formulation of a rule at all. So let me just give you an example of something that I think is a constitutional construction, takes place outside the courts, but does not involve judicially created doctrine. We have the advice and consent clause of the Constitution. The advice and consent clause requires that there be some relationship between the President and the Senate, right? And that relationship could have been structured in a number of ways. Early in Washington's first administration, Washington had an idea about how it was supposed to be structured. Washington thought the advice and consent clause made the Senate much like the Privy Council, and he actually summoned them to his home, and he was going to, like, question them. What's your advice?
He went there.
Yeah, he
No. He summoned them. They didn't come to his home. You haven't heard the rest of the story. You haven't heard the rest of the story. He summoned them to his home. They wrote back and politely declined to come over and give him advice in the way that he had asked. And instead they said, no, the way this is going to work is that we are going to give advice and consent as structured by our own internal rules and processes. That then set a pattern of constitutional meaning that's persisted ever since, right? The Senate, when it gives advice and consent, meets an executive session and they follow their own rules, and the President doesn't have the power to summon them and ask them, for instance, one by one for their advice, right, and consent. So that's in my view, that's a constitutional construction, but it took place entirely outside of the court, right? And it never resulted in anything that's in a treatise or that has been stated as a rule, right? It resulted in a practice. So I would want to say that that practice is a constitutional construction, very different than the kinds of constructions that the courts typically engage in. I think that there's a question, a real question, that you raise about the kinds of examples Larry gives. These are sort of the implementing rule examples, like burdens of proofs, whether these are constitutional constructions or not. In my view, they probably are, because they are sort of part of the implementation of the constitutional text, right? They're part and parcel of it. But I can imagine us dividing up the world in a slightly different way, so that we would call those things something else, right? And the only thing I would say is, whatever we called them, whether we called them constructions or something else, they are not interpretations in the sense that they are determinations of the linguistic meaning of the text. So if you want to, I could be persuaded that the term construction, right, should be given a narrower meaning. And I believe that these are fundamentally, these are technical or stipulated meanings, right? For the purposes of the common law, it's a technical meaning, but in constitutional discourse, I think we're actually dealing with stipulated meanings, because the distinctions we need to draw go beyond the distinction. The distinctions that are useful to us as theorists go beyond the distinctions in the common law. So they might be based on it, but not reducible to it. So it would be a conversation I would be willing to engage in as to whether or not these things are properly called constitutional constructions.
We have 7 more people on the queue.
Now, this is a question for Larry, and I apologize for this question, but I'm not somebody who's real knowledgeable about all the writings in this area by any means. When you talk about the author's purposes or intent, and we're looking at Congress, and we have a particular person who wrote the provision, and then we've got a committee which proposed it, and then we've got a majority who voted for it, who do you treat as the author?
This is the old multiplicity.
Yeah, sure.
Right. No, perfectly. This is a question. So if you start off with a model of a one-to-one communication, your mother sends you a letter, your wife sends you a shopping list, right? And then you go from that to imagine 2 people. Let's construct a shopping list. 2 fraternity brothers, for the third who's going to go out and get the beer and pizza. And they construct the list. Now, I am perfectly cognizant of all the problems of aggregating, intended meanings across persons and the like. And it may be that there are certain documents, I can think of many things that were done by our faculty, which look as though they are intelligible when you parse them, so you come to the next meeting and you say, what did we mean by this? And it turns out that there was no common shared meaning. In fact, if somebody meant A, somebody else meant I wouldn't have voted for it if it meant A. It means B. I think there are a number of things where there is no, I think all I can say is I think, just imagine that 3 people sit down to write something, and they use the same marks and sounds, but they mean entirely different things about it. Well, I think the question, what did they mean, is unintelligible. Right? So I think the question is, there are these shared meanings. Now, unfortunately, I think collectively there frequently are shared meanings. But I don't think that you can disembody the meaning, so that whatever the people who wrote it meant by it, it somehow has a meaning that floats free of that, because it's just marks and sounds. It's not, even the question of whether it's in English. Well, that's because those people were speaking English. It's not because Marx identified themselves as English. And so It's not that I'm happy with the problem of multiple authors. It's just that I don't see any way around it.
Steve?
Okay, I like the paper. It was short. It was sort of elegantly written. It seemed like it clarified a lot of things, provided a landscape and so forth. I had sort of one problem with it, I thought, and it didn't exactly come up in your presentations, so I wasn't going to ask about it, but it felt to me like it did come up when you were responding to Mike Rappaport and maybe a couple of other things, so I thought I might try this anyway. So Mike, I understood basically to offer you sort of two possible accounts of what the difference is between interpretation and construction, and somewhat to my surprise, I think you sort of took the second one and then tried to subsume, use that one to so that it could cover the first one as well. But I actually thought so let me put it this. Insofar as interpretation and construction is a response to this phenomenon of vagueness, that seems kind of commonsensical. Maybe everybody would acknowledge that something like that happens, however we would want to label it. And it seems like you understand that in terms of the, let's say the implier, I don't want to say interpreter now, I guess, but whoever, the implier, understanding that they are adding something that couldn't just be deduced from the original meaning, whether that's intentional meaning or public meaning or something like that, and it's nice to have a label to describe that because that does happen. But that I understood you not to accept as sort of like now the primary thing you're about, but instead it has to do more with the distinction between semantic and legal content, or semantic and legal meaning, and then you say that distinction applies in every case, even where the two almost will be identical, and you're trying to do work with that. And to me, I probably just don't understand what this is about, but it seems like a misstep. It seems like it detracts and confuses. I'll put it this way. It doesn't seem to me that, for example, legislators would almost ever think in those terms. That we're enacting something that has the following semantic meaning and the following legal content. They think they're just, when they say we're enacting something that says every state gets 2 senators, to divide it into a semantic and a legal content, it seems to me would be quite unnatural to most legislators. It would, I think, be quite unnatural to most appliers, judges or legislators. They just think that those are the same thing. And they would not think, as in the vagueness situation, that when we say the semantic content is that every state gets 2 senators, and the legal content is that every state gets 2 senators, that the second thing is sort of adding on anything. They just think of this as some unified thing. Now, it is true that they would sometimes have to make answer additional questions, like in deciding a particular case, how much force do we want to give to that enactment? And maybe sometimes we'll disregard it, or maybe it'll be overcome by precedent, or one thing or another. So they would have additional questions they'd have to answer, but I don't think they'd think of any of those things as well, actually, I take that back, but I'll say it anyway for now. They wouldn't normally think of those things as figuring out the meaning of, the semantic or legal. So I just would suggest that, at least to me, trying to put the vagueness problem in terms of this other distinction confuses more than it clarifies. At least, now you may have other things that you're doing with it, or other people might react differently, but that's the way I would react.
Laurie, I think my question is really much the same. If I might just add mine to it before Larry responds. I was similarly confused or bothered by the formulation of construction as being the legal content, and particularly emphasizing doctrine to this degree, or the determination of doctrine. My normal way of explaining it is much the way Steve has said, which is that you have the ascertainment of a linguistic meaning, and then you have the application of that linguistic meaning to particular facts and circumstances. Sometimes when that linguistic meaning is unambiguous, it could be in some sense directly applied, but where it's vague, there needs to be intermediate steps of determination in the course of application, and the application could be by courts, or the application could be by other actors. And if it's by courts, it might involve the development of doctrine, but if it's by other actors, it would not involve the development of doctrine. But to me, it was the linguistic meaning and then the application of that linguistic meaning in cases of vagueness requires construction. Now, construction might also include other activities such as what you mentioned. But in the way you formulated it here today, I had the same reaction that I think others have had, that it's easier for me to understand it myself if I think of the linguistic meaning versus the application of linguistic meaning. That's not the way I thought you explained it today.
I have thought about and rejected this approach that says that there is semantic content and then there is just application, right? Because I believe that creates a gap, right? And the gap is that the legal content of a rule does not necessarily correspond to the semantic content. So let me just, Steve, let me just try to get this going for why there is a difference, a real difference, right? Not, and I'm really trying to have the distinction mark the real difference in the world, right? Not to have it be, in the first instance, useful, right, as a heuristic for proceeding, right? And the two things can come in conflict. The real difference in the world can lead to a distinction that's not the most useful heuristic, right? So the real difference in the world between semantic content and legal content comes up in all kinds of situations which are not the typical situations that we deal with when we have a clear text. But let me just give you one. You can have a legal text that is no longer in effect, right? And in that case, it is clear that the semantic content or the linguistic meaning of the text is non-identical to the legal content that we derive from it and then use to resolve cases, right? Why do we know that? Because in this case, the text is no longer in effect and has no legal content any longer. It has no enforced legal content. It could have hypothetical legal content. It has no enforced legal content. Likewise, there are lots of situations in which we have an enforced legal provision, and it turns out for one reason or another, and this happens in statutory interpretation and contract interpretation, it happens for one reason or another that the legal content that we derive from the text, the legally effective text, varies in some way from the clear linguistic meaning. And this happens, for example, in contract interpretation when you have a provision of a contract that runs into a default rule, right? Now, it might be that we don't have to get rid of the entire provision of the contract. There may be a saving construction, right, that gives the provision of the contract legal content that varies from its semantic content, right? That's relatively rare. It may never happen, or it may be that it never should happen with respect to the Constitution. But this is a real distinction between the semantic content and the legal content. The fact that we don't think about it when language is clear, that we normally don't think about the systematic difference between semantic content and legal content, that's absolutely true. We normally don't think of it. That's because if the semantic content is clear, under normal circumstances, it can just be translated into legal content. But it's not necessarily the case that we'll do that, right? And there are some theories. This distinction is intended to be neutral as between particular theories of constitutional interpretation and construction. There are some theories of constitutional construction, or what I conceive of as theories of constitutional construction, that argue that there can be systematic variation between semantic content and legal content, right? And Dworkin's theory is, in my opinion, such a theory that it does not, on Dworkin's theory, it does not have to be the case that the legal content that corresponds to a particular provision of the Constitution is constrained by the semantic content, right? It's the legal content is determined by the theory, the moral theory that best fits and justifies all of our practices. And on that theory, it can turn out that a particular constitutional provision is a mistake. Now, I don't agree with Dworkin about this, but the fact that Dworkin can take this position shows that there is a conceptual distinction between semantic content and legal content. You then apply legal content to resolve the case, right? And you could talk about it this other way, but you will then be missing something that is absolutely essential for us to understand conceptually the way that the linguistic meaning of legal text relates to application. There is an intermediate step, and that step is captured, I believe, by construction.
I just add one tiny footnote on that. I think your best example for this is the things like the Ashwander doctrine or the Lenin doctrine, where it's clear the linguistic meaning of the statute is different from what its legal effect is. I also happen to think the Ashwander doctrine is absurdity, but I do.
And then there's the absurdity doctrine.
Well,
The absurdity doctrine is better than the Ashwander.
Can I just want you, I'm going to lay out a particular conception of construction. I just want you to comment on it. I read Keith differently, or rather, it wasn't that I read Keith differently, it's that I built out my theory differently based on reading Keith. So this is what happened. Yeah, well, this is exactly the point. This is exactly the point I'm making. I understood what Keith was working on, because he was working sort of vaguely in the American political development field, as trying to give an account of how constitutional states build out institutions over time, and using the Constitution as materials for doing so. And then the results of that themselves became institutions and things that you built on and just built out over time. So for me, instead of trying to assimilate construction in Keith's sense to what judges do, I, in a very perverse way, began to understand judges as being an arm of American institutions, political institutions. And so I understood the work of courts as being like the work of Congress in building up the Defense Department or the Justice Department, or creating federal marshals, or stationing troops overseas, or building post offices and post roads, right? All this stuff we call state building. And what courts are doing is, in effect, they're deciding cases and they're creating doctrine. When they decide cases and they create doctrine, they not only resolve situations before them, but they also leave a residue in the form of doctrines and procedures and all these things. And all these things struck me as being constructions, just in the same way that building an army and putting it around the world creates a construction of the president's power to deploy troops and Congress's power, fund troops, which then creates a reality on the ground, which shapes how people imagine what the Constitution means in practice and how we understand what's legitimate. That's what I took from Keith when he talked about construction. And so that's why it seemed natural to me to think that this is why, when you say legal effect, what I mean is you build out a doctrinal system designed to sort of put the Constitution in operation. And so there's often going to be a gap between legal meaning between the semantic meaning and the constructions. So, for example, you have public forum doctrine, First Amendment. That's construction. What it does is it basically builds out a system, a way of applying First Amendment values to a certain set of problems, and then that thing gets ramified over time, right? And over time what can happen is that the constructions can become further and further removed from what we think as being the general underlying purposes of a constitutional text, right? And people get different views about that. So some people think Citizens United is the breaking point, that the doctrines that have ramified now have broken, and they've broken free of the purposes of the First Amendment. Other people think, no, this is in fact the point in which we finally close the circle and bring the doctrine back to its true purposes, right? It's just different conceptions of what the construction did. That's what I thought was going on with construction. And I think the problem is that when you assimilate it to the old distinction in common law distinctions about judicial practice, you miss that state building element. So I'd like you to comment on this very different perspective on what construction is like.
So I must be theoretically tone deaf, right? Because I just don't hear what you said as fundamentally different, right? I do hear, and maybe what's going on is this, that
How about this? The
I'm
Social
trying-
Security Act of 1934 simultaneously is a construction in the sense of interpreting the meaning of the spending clause, and it's a reality on the ground that creates an administrative and welfare state, which will then force the Supreme Court to declare it to be a constitutional exercise of the spending power, thus changing the nature of the American political regime. Okay.
So, as I understand this example, right, the passage of the statute may or may not have involved Congress engaging in an action of interpretation. They may or may not have been thinking about the linguistic meaning of the constitutional text, right? And if they were thinking about it, they might have been right about it, they might have been wrong about it, or they might have just proceeded on assuming that it's okay, perhaps because it was inconvenient to think too much about the linguistic meaning of the text. They then have engaged in a political act that results in a change on the ground, as you say. And then that change on the ground could, in turn, require the Supreme Court to engage in the construction of constitutional doctrines which fit that change on the ground. Those constructions that the court engages in might or might not be consistent with the linguistic meaning of the text. For the sake of argument, let's assume they're inconsistent, right? That, in fact, if you had thought at the beginning about the linguistic meaning of the text, this particular statute would not have flown, right? But now the statute's on the ground, it's generated expectation, it's become part of the fabric of political life, and the courts react to that. One way they might react to that would be now to engage in what I would call, you could give it different names, but I would call it an amending construction of the Constitution. That is, they now come up with a legal doctrine, right, that is no longer consistent with the semantic content of the Constitution by hypothesis, right, because I'm building out an elaborate hypo. Now, what do we say about that amending construction? Well, different theories of legitimate constitutional construction by both the judicial and political branches will have different things to say about amending construction. Originalists, as a group, tend to believe that amending constructions are illegitimate, right, because they lack fidelity to the semantic content of the text, to the linguistic meaning of the text. But other theorists, right, some kinds of living constitutionalists, moral readers, might say, well, you know, perhaps the fact that this construction that is developed in response to the statute, perhaps it counts against it that it's not consistent with the linguistic meaning of the text. But that's not the end of the matter, because we have multiple modalities. And in this case, historical practice and the felt necessities of the time and reliance interests and whatever it might be provide us with warrants for this amending construction of the Constitution. Now, just one more little bit here. Because admitting that you're engaging in amending constructions is delegitimate, it might well be the case that a court would be tempted to do one of two things. Either to sort of ignore the question whether or not the amending construction in fact is consistent with the text, or to fudge the linguistic meaning, right, by engaging in an interpretive practice that involves dissimulation. And you can certainly imagine that, you know, there would be lawyers' arguments that would be made that would make that dissimulation sound plausible. So that might be another thing that would go on. But I see the kinds of things you're talking about as constructions.
Right. Because John Harrison can't join us at dinner, let's let him have the last question and come in now. We're over time. Please, John.
For my question is along the same lines as Jack, fortunately. And it is that if the category that you're just describing qualifies as construction, isn't it also true that a positive theory of how such things happen is distinct from a theory of as a legal phenomena, a theory that will tell us whether it's legitimate or not, and that I think a lot of what Jack was asking about was where is the place for all this of the positive theory, the political science account of when constructions take place, what follows from them, which are more likely, which endure, and which don't endure. So is the category one that can also then be understood as a matter, say, of political science, American political development?
Yeah, so yes, there are two different questions here. There's a positive question about how constructions arise, what forces produce them. And there's a normative question about what constructions are appropriate or legitimate. And there are further normative questions from within the legal practice about which constructions would be considered legally valid by members of the community that engages in constitutional argument. Now, those are separate questions. The positive question as to why we get the constructions we get, the normative question as to whether they're legitimate, including a subtype of normative questions, the legal questions about whether they are consistent with our legal practices.
Well, let's go to dinner. Thank you very much.